Kaiser, other members of the Slovenian Pan-European Union, Excellencies, dear guests, ladies and gentlemen, it is a special honor to be here. It's a special honor to be here in this circle because Pan-European Union has played such an important role in Slovenia for long times, but in particular in the days leading to Slovenia's independence, Pan-Europe was a very instrumental and very important player supporting Slovenia's wish to realize its right to self-determination. So in a way, with a kind of gratitude, I accepted this role to chair this panel. I'm also very glad to see here many young faces, young people, which shows that in these days, when there is a lot of Euroscepticism around, without any good reason, I would dare to say, young people nevertheless pay attention to the idea of Europe, to the idea of United Europe, a Europe which will be a guarantee for the welfare and security of its inhabitants. This panel, which I am supposed to chair, it is a difficult topic, I must say. When I was last night, because just before of that we had a long session of the Constitutional Court dealing with a very important and very exciting and sensitive topic of our constitutionality right now, I realized that it is not easy to establish the linkage between foreign policy, including European foreign policy, and constitutionality. It's not easy. There's also not much literature on that. It is a topic which really needs attention. Yes, it's a good topic, but it's not a simple one. So then I decided to chair this, to moderate this roundtable in a way not to search for a kind of conclusion which we should come to, but as a kind of touching certain aspects and try to put some light on them, a kind of leopard skin, clarifying certain things, but without any ambition to come to a kind of general conclusion. I will chair it in a way that I give the floor to my colleagues who will speak for 4, 5, 6, 7 minutes on a topic. And then at the end, I will try to devote some minutes to A&Q session, answers and questions. But if somebody during our debate finds it necessary and wants to make a remark or to ask some additional question, just raise your hand and I will be pleased to give you the floor. Now, when we go to the topic, of course, the basic legal ground for common European policy is there. These are the treaties, basically Lisbon Treaty and others. We don't need to go into that. There are some established principles which are clear, what principles on which European foreign policy should be based upon. But in this particular topic, we should keep in mind that the foreign policy was always the most exclusive part of sovereignty of states. Now, the question is, what are the constitutional limitations to foreign policy? Constitutions usually regulate the organization of foreign organs in a state, distribution of responsibilities. Constitutions usually regulate the process of ratification of treaties, usually constitutions regulate some other technical aspects of foreign policy, and also we establish some basic principles, constitutional principles, which of course also a foreign policy of state should follow. But nevertheless, the question is there. How far foreign policy can be and should be under constitutional control? Because foreign policy, as I said, it's per se a typical expression of state sovereignty and has its own specifics. One of them is that it is many times pursued in a process which is secret, which is not public, lack of transparency. So that is maybe the first thing which I would like to raise in this panel, and I would maybe ask Professor Kershevan if he would be ready to react to this particular topic. You have the floor.
Thank you. Well, thank you for the invitation, and the topic, of course, is complex, and there will be many questions unanswered. And as Mr. Petric already said, we won't be discussing the legal basis for the European foreign policy in detail, which is, of course, something that would exceed the mandate we have. But we'll be dealing with issues that probably are, in our opinion, maybe complex, maybe important at this point in time, and maybe unanswered in the legal field as well. If we go to the question of constitutional issues regarding the foreign policy, if there is any connection, I would say that, of course, there is, and there will be more of them in the near future. I remember a discussion that we had in Karlsruhe with the German Federal Constitutional Court 3 years ago, while I was still Secretary General to the court. And we touched several topics, but I remember one debate we had about international policy and the effect the Constitutional Court in Germany had. We were discussing the issue of arbitration agreement with Croatia at that time, so that was quite an issue. And I'll come to that in a moment. And there was a question whether the Constitutional Court in Germany had any confrontation with the foreign policy demands in its history, and said, oh yes, there is a painful story about that. I will omit the names, the year, and of course the exact question, but it was about the Constitutional Court of Germany deciding about foreign agreement, an international agreement with the German Democratic Republic at that time. And they found, of course, some constitutional problems with that, which angered the government making that agreement. And the, of course, painful part of the story is that one of the members of government at that time said something like in German that I'll be using non-diplomatic phrases, but it was said as such, that die neuen Arschlöcher in Karlsruhe werden mir die Ostpolitik nicht diktieren, which in translation would be 9 morons from Karlsruhe. The Constitutional Court will not dictate my Eastern policy. And this was one of the questions, of course, that shows how important constitutional issues can be when dealing with the foreign policy. And of course, as mentioned before, we had one of the cases which is also very sensitive in diplomatic relations in our Constitutional Court, is what it wasn't directly touching human rights, but it was touching an important question of national sovereignty and the fundamental papers, fundamental acts on which our sovereignty was based. It was a question posed by the government to the Constitutional Court whether the arbitration agreement to delimit the border with Croatia is in accordance with our constitution. And if I just point out just one of the questions that was raised by Mr. Petric a moment ago, the question of secrecy, which can affect, of course, different constitutional aspects, but this was interestingly one of them, is that in this proceedings, the government brought, well, a few boxes of top secret documents to the Constitutional Court supporting their claim, which of course were top secret because of the nature of negotiations that were used to form this agreement? Or is this, of course, maybe too strong a word? But the problem the Constitutional Court had at that time is, well, first to store them. It was something that we did in the very cold chamber in the basement. But how to use them? Can the court use top secret documents which are derived in their nature by the process of diplomatic negotiation in a constitutional proceeding? Can the opposing, interested and other parties be informed? Can the court reveal or disclose some matter in these documents? Can it form its decision, its judgment, based on facts which are secretive? And, of course, rule on the matter affecting the fundamental questions of constitutionality in our system. These were, of course, questions derived from practice. Whether this illustrates some of the difficulties the court has to face with other questions of secrecy is, of course, relative. But it's something that that shows that these issues can occur, this overlapping of diplomatic rules and practices with constitutional court proceedings and decision-making, also in maybe relatively unexpected cases and instances. I won't be too long. We'll be talking about several issues, I believe, further on. But there are so many developments that show that foreign politics and foreign policy is not getting more independent of constitutional issues, but on the contrary, it's getting more and more bound by human rights, by constitutional orders of the European Union and of the member states and international agreements, that we'll have soon an interesting question that will be discussed later on. If we change diplomatic practices and diplomatic relations more and more with binding documents of international law relating also to human rights, like European Convention of Human Rights, the EU will be accessing to that convention eventually. It's a complex issue. Is that a positive development? On the first hand, we would say, yes, of course. Well, more human rights, the better. But, and I don't know if there is a study done in that regard yet. Is it better to try to solve complex cases of issues affecting the relations between states, like questions of migrations, asylum, different aspects of human rights that affect, for example, non-EU member states, but members of the Council of Europe, in courts or through diplomatic negotiations, as it was till now? I'll stop at this point and, of course, give the word back to the chair. But I find that there are many, many issues where constitutional questions have been raised and will be raised, and of course we'll have some time to discuss them today, hopefully. Thank you.
Thank you, Mr. Cashman. I agree, and I plan that we devote a few minutes later on to one very exciting topics which occurred 2-3 years ago. Since this idea that European Union joins the Council of Europe as a member, which means also as a party at the court in Strasbourg and so on, because it is an exciting topic which has to do with constitutionality, and it is also an exciting topic because in particular this topic will be this year discussed in Vienna, the relationship national constitutional courts, Strasbourg, Luxembourg, relationship national constitutional courts and international courts, in particular international courts on human rights. But we will come back to it. But at this point, I would maybe ask you, Mr. Bachler, since you have in the Constitutional Court of Austria many interesting cases, could you maybe elaborate a little bit what are the results, or what are your understandings concerning this particular relationship, foreign policy, constitutionality, based on the work of the Constitutional Court of Austria, whereby I would add a special subtitle: Austria is a special case because of its permanent neutrality. And maybe you add a few words now or maybe later also on the understanding of constitutional aspects of permanent neutrality, which is a category of international law, but also a constitutional principle of Austria in Austrian foreign policy. I would be very grateful if you would say a few words also on that.
Thank you. Yeah, in the recent jurisdiction of the Austrian Constitutional Court, you can find fundamental ideas which are relevant for our subject. There are two judgments, in my opinion, which are of specific interest. The first is the judgment from 16 March 2013 concerning the ESM Treaty, the treaty establishing the European Stability Mechanism. I won't go into details, into technical details, but the main ideas, I think, are of specific interest. Why? First, a very interesting question for the court was the extent of participation of the parliament in the procedure of the transformation of an international treaty into domestic law. Of course, in the specific case, these were procedural questions, but the idea behind all that is the question of democratic justification and therefore of fundamental importance. The range of parliamentary competencies is a topic not only from interest for a constitutional court, but also for politics. If you think about the European Union, it's, in my opinion, one of the key questions, the range of competencies of European Parliament. So the more acceptable decisions are, the more democratic they are, one can say, for the citizens. And therefore, the Austrian Constitutional Court was interpreting the interpretative clause which was concluded by administrative bodies after the conclusion of the ESM Treaty. And that was a question of significant importance. The second question, in my opinion, affects the status of the Austrian Constitutional Court itself. What kind of questions are for the Constitutional Court to assess? And this question refers to the judicial self-restraint of the court. That's a very important question because international affairs and international treaties are always dealing with political questions. And there is a border for a constitutional court. How far can it go? And you must see that these two questions are deeply connected with each other, because the question of a democratic justification is always seen in a procedural way. So what procedural guarantees are important in such a transformation process? And this specific kind of transformation of an international treaty leads you then to very fundamental political questions, namely the political question of democratization. And the third question concerning the judgment of the ESM Treaty is dealing with the question to what extent sovereign rights can be transferred to international bodies. We have in Austrian constitutional law restrictions. This is the Article 9, Section 2 of the Austrian Federal Constitutional Act. And the Austrian Constitutional Court has always a very liberal position. So the Austrian Constitutional Court rules that these restrictions must not interpret it too narrowly. And this leads me to your question about neutrality. I think these two approaches, so the neutrality on the one side, and this liberal understanding of the extent of sovereign rights, they can be transferred to international bodies, they are deeply connected with each other. So the policy of neutrality in Austria was always one of a very active one. So Austria was very soon a member of the United Nations, and the understanding was always rooted in two principles. The one principle is the democratic principle, which is very important in the jurisdiction of the Constitutional Court, and the other principle is that of the rule of law. And both you can find, in my opinion, I'm not a politician, but it's my personal opinion, but these two principles play also an important role in the European Union. And so you have to see and understand the policy of Austrian neutrality. And this leads me to my last point and to my last question. When we look at the judgment of 14th of March 2012, this was dealing with the Charter of Fundamental Rights of the European Union. I think this is very important because for Austrian Constitutional Court, the European Union law was never a standard of its own judicial review. But with the entry into force of the Charter of Fundamental Rights of the European Union, this changed. And this is changed because of a special domestic constitutional setup of the Austrian constitutional law. So the Austrian Constitutional Court, in its self-understanding, sees it as a centralized competence in dealing with constitutional questions. And the Austrian Constitutional Court ruled that the Charter of Fundamental Rights of the European Union is markedly distinct from the treaties, from the other primary law. And this leads us to the topic and to the subject of the relationship of the Constitutional Court, the Strasbourg Court, and the European Court of Justice in Luxembourg, because we can discuss it further on more.
We will come back to it.
Okay, yeah.
Yes.
Thank you.
Because it's very exciting topic, although of course, like most of the lawyers' topics, not very exciting on the first sight. But when you go deep and profoundly in them, they become more and more exciting. I know that as a lawyer and at the same time as a former diplomat, so that sometimes for non-lawyers, for lawyers exciting topics are not so exciting for the non-lawyers. But I hope we are here on the limit and not crossing it yet. But the next question which I would like to raise is, and I would like to have the President Dedia to react to it. It is, of course, yes, problems of international character, problems of foreign policy in the constitutional arrangements, and maybe to have a presentation of such a case from the point of view of Albania. I know that some cases concerning international law were dealt with by your Constitutional Court, in particularly a topic which is, of course, connected to the transformation of treaties into the national law. And President, you have the floor.
Thank you very much, Mr. Petric. Thank you very much for invitation, Mr. Kaiser. I have prepared some words for international agreement from the viewpoint of the Constitutional Court of Albania. First of all, I apologize you for my English language is very bad. Constitutional jurisdictions over the control of international agreements as foreign policy matters slightly distinguished the politics from the law. Constitution of the Republic of Albania has sanctioned that Albania applies international law that is binding upon it. The content and spirit of our Constitution create the necessary opportunities for the delegation of competencies serving these two peace, democracy, and prosperity through bilateral and multilateral agreements where our country presents itself as a sovereign country with all the attributes derived from such status. This discussion is based on the premise that constitutional review of international agreements as compatible with the Constitution, as well as constitutional review of normative acts as compatible with the international agreements, exert the influence upon the competencies and function of executive of legislative power in order to decide on political issues or establish the relation between Albanian states and the international organization and others, or into aspires to other. According to the money system, the international law has superiority over the domestic law, and it is directly applicable. The money systems offers two options: the international money systems and national money system. The first recognizes the supremacy of the international law, whereas the second recognizes the supremacy of constitutional national law. I think that the Albanian case is a mixture of both of these options. The Constitution has reserved the first place to itself as compared to the international law, but has recognized the supremacy of international law in case of limitation of human rights provided for in the European Convention of Human Rights. In any case, the Constitutional Court cannot recommend the best political solution in a certain situation. It can only state what is allowed or not to the politics from the constitutional or legal point of view. Beyond and thus the Constitution is not only the highest act in the hierarchy of norms, but it is also a political document that contains solutions and choices even for the politics itself. A decision of the Constitutional Court declaring the incompatibility with the Constitution of an international agreement may give rise to strong debates about the legal and political consequences, as the state's responsibility in the international arena lost the credibility as strategic partner before the international community. I would like to present the position of the Constitutional Court with regard to the ratification of the Rome Statute of the International Criminal Court, as well as the incompatibility of the so-called Sea Agreement with the Constitution. Both of these decisions rendered after the exercise of a priority control may be considered as historical in the 20 years decision-making activity of this court due to their significant importance in foreign affairs. In his decision number 186/2002, appellant the Prime Minister of the Republic of Albania and objects incompatibility with the Constitution of the Republic of Albania of the Rome Statute of the International Criminal Court, Constitutional Court decided that the Statute of the International Criminal Court, established by the Rome Treaty, signed by the Republic of Albania in 1998, is in conformity with the Constitution. In this decision, Constitutional Court has stated that given the fact that in pursuance of the Constitution, the generally accepted norms of the international law constitute part of the domestic law, then the lack of the immunity of the international criminal proceeding for serious crime becomes part of the Albanian legal system. In its decision, number 15/2010, appealing the Socialist Party of the Republic of Albania and the objects the examination and the compatibility with the Constitution of the Albanian of the agreement between the Hellenic Republic and the Albanian Republic on the delimitation of their respective continental shelf areas and other maritime zones to which they are entitled under international law. Constitutional Court decided on the incompatibility of this agreement with the Constitution. Partly, the statement of the reasons was based on the argument that, from the legal point of view, representation of the state as subject of the international law in foreign affairs by the government without the preliminary authorization of the President. It is a question of the international agreement of political nature, comes contrary to the principles of the rule of law. Through this decision, the Constitutional Court gave prevalence to Article 92 of the Constitution, which has foreseen the President as a competent organ to enter into international agreements according to the law, and did not take into consideration, let's say, the customary tradition of signing of international agreements, according to which, if the other party does not request the full power, then it is not indispensable. Another essential function having a considerable impact on the foreign policy, especially on the integration process very much inspired by our country, is a review of compatibility of the legislation with the obligation deriving from the Stabilization Association Agreement as an agreement coming after the Constitution in their hierarchy of norms. According to the Constitutional Court, the limitation of human rights, particularly those related to economic freedom, should be considered not only with respect to the Constitution, but also to the Stabilization and Association Agreement. I could be said that the Constitutional Court established the boundaries of the activity of executive and legislative power in conformity with the constitutional principles, even in delicate field relation as the foreign affairs. Thank you.
Thank you, President. Yes, of course, all countries have this problem of transfer, of integration of international law into their domestic law. I think Slovenia's solution is pretty good, but it is interesting that it is not the same solution found in all European countries. There are differences, and maybe one day, in the process of future integration of the EU, this process, how to integrate the international law into the national law, is probably one topic which should be possibly unified. That's my personal opinion. You shouldn't have in the European Union different ways how you transfer international obligations in your national law. Probably that should be one day discussed and possibly unified. You know the Slovenian situation. The Slovenian situation is very logical and very, very good, I would say, very functional. In our system, on the top is the Constitution, then international treaties and general international law, and below, laws. But to avoid a situation in which might occur when we would ratify a treaty which might later be found unconstitutional, we have the preliminary constitutional control, which can be pursued by the Constitutional Court. So in advance we say, this treaty you cannot ratify because it is possibly unconstitutional. That was particularly the case famous case of the arbitration treaty between Slovenia and Croatia, which was mentioned here by Professor Kershman. But I would now maybe like to make a next step ahead, maybe a little bit into the direction of politics. Yes, foreign policy is an expression of state sovereignty. But the question is, what are the constitutional barriers to this sovereign right of a state to pursue its foreign policy? And what are possibly then the limits, constitutional limits, for its foreign policy? I would dare to say that human rights, it's for sure, for European countries, a constitutional must. All European countries have, and other countries too, of course, but we are speaking here of the EU foreign policy, that's why I'm limiting myself to this, have the principle and a long catalogue of human rights. One could conclude that this means that in their foreign policy, European states and EU as such should respect and pursue human rights. They should even, I believe, be actively supporting promotion of human rights at home and elsewhere in their foreign policy. But we have here exciting cases of cooperation of countries which are bound to respect and pursue human rights with states which grossly violate human rights. Is this a problem or not? We have, even in domestic yard, interesting situation. The last one, the Swiss decision limiting the free flow of people. Even within the European Union, Switzerland and Croatia. Maybe Professor Kershman, you could say a few words on this topic. Not necessarily, I don't ask you to connect your statement with the Swiss-Croatian case. You can if you want, but basically the problem of constitutional principle, which I consider a jus cogens, respect for human rights and foreign policy. Does it mean a kind of compulsory orientation for foreign policy of, let us say, since we discuss it, European countries, members of the EU?
Thank you. I will, of course, try to a bit supplement the absence of Madam Omejec, the President of the Constitutional Court of Croatia, who's a wonderful person but couldn't be with us today, unfortunately. And I will talk about the Swiss-Croatian dispute, and I'll start with some legal details as to that. The Swiss, of course, as everybody knows, held a referendum saying they will limit the immigration to Switzerland. And the people voted yes. And that binds constitutionally the Swiss government to prepare changes of laws and bylaws to, of course, respect that decision. The first victim of that decision was a change in a foreign policy, not a document, a foreign policy, whereas Switzerland abstained from ratifying or signing at that point the agreement with Croatia about establishing free movement of persons, which was of course based on the principle that the same agreement or similar agreement was made with other members of the European Union as well. So here we have an effect of a legally binding issue under the national sovereign, of course, constitution that affected the foreign policy of Switzerland and actually positioned Switzerland as a foreign country in relation to the EU in spheres or areas which were regulated by an internal policy, internal rules. And this happening is, of course, interesting as to the both political, but I will talk mainly about legal consequences this might have. Politically, of course, now maybe the motivations are different as to the relation of limiting immigration. I would say that Germany is not pushing for a severe sanctioning of this decision because of Croatia. But maybe it has to do something with an enormous number of German citizens working in Switzerland, but I will not speculate as to the reasons of politics. But legal arguments can be seen first in question whether this is not as an internal area of EU law, dictate that the European institutions in common foreign policy act to protect the discrimination of one of its member states and its citizens. So we have, of course, under the EU Charter and other documents enshrined for a long, long time, of course, protected by the jurisprudence of the courts of the European Union, Luxembourg, the non-discrimination among citizens of the European Union. And this decision of Switzerland causes that discrimination in the sphere of the foreign policy. So what would be the legally proper or binding even reaction to protect the human rights, non-discrimination enshrined also in the documents of the European Union in this respect? Is it legally binding to sanction such an action? Could it be? Could it be enforceable somewhere? Or does this, of course, affect the questions of the validity of other agreements with Switzerland? This, of course, is something that not the courts at this point in time, but the foreign policy bodies will have to deal with, both of member states and the European Union itself. But similar issues are raised and will be raised more and more in the courts of law because of the before mentioned question of accession of European Union to the European Convention of Human Rights. I've seen the document. It's quite long. It has about 20 pages. It's detailed draft now. And the European Court of Justice will have to give its opinion on that. So, European Courts of Human Rights thereafter as well. But it'll mean juridification of many foreign policy issues, even in my view, in my opinion, and several others, of course, who are more capable in this field. I've read several discussions about that, quite interesting, that say that, of course, this juridification of European Union actions, there being the member of the Council of Europe, will, of course, lead to the similar issues of immigration, emigration, asylum, etc., to be resolved not only through diplomatic negotiations, but through court action against the European Union, who will have to respect the decisions of the European Court of Human Rights in Strasbourg, which will affect its foreign policy powers and, of course, its orientation, not just in general principle of pursuing and protecting human rights, but with more detailed and concrete binding instructions by the court how to prevent human rights violations from happening. And that, of course, is something that can be maybe foreseen or predicted at this point in time, and will, of course, be a positive development as hailed by many, but it will cause many, many problems in this regard, I'm sure, because being bound by the judgment in the sphere of foreign policy, as was, of course, presented by the President of the Albanian Constitutional Court, Mr. Bashkim Dedja, moments ago, is something completely different than pursuing in principle the human rights and other constitutional valid principles. So let's see what will happen in this regard. And I hope that, of course, the solution of the problem that our neighboring friendly country, Croatia, has with Switzerland and is arising from this will be resolved in the spirit of protection of human rights and non-discrimination in this regard. So I would stop at this point. Thank you.
Yeah, well, yes, maybe later when we come back to the relationship Luxembourg, Strasbourg, national courts, you may touch it again if the time permits. But maybe to have some your reactions to this, Mr. Bachler, and also I would like maybe if you dwell a little bit in this context with the very extensive practice and very important practice of Constitutional Court of Austria concerning asylum.
Yeah. Your question refers, in my opinion, to the relationship between the democratic principle and the rule of law. Why I say this? If you look at the case of the ESM Treaty, concerns have been raised that the ESM Treaty was non-objective and therefore in violation of the principle of equality and inconsistent with the principle of economic, efficient and effective government management, which is guaranteed by the Austrian Constitution, and moreover contrary to sustainably sound public finances as a state goal stipulated in the Austrian Federal Constitutional Act. And there, the Austrian Constitutional Court ruled that these are legal policy issue questions and they are not for the Constitutional Court to assess. So the control for the Constitutional Court is only not to control politics or government decisions in economic affairs, but to control the process, the procedural process. If the procedural process guarantees the democratic justification, guarantees the participation of the National Council. This is very important. And in my opinion, this is because these two principles, the principle of democracy and the rule of law, are deeply connected with each other, and they depend on each other. And the democratic principle, in my opinion, is only restricted, and the borders for these democratic principle are at least the human rights, yeah, and the fundamental rights. But under this scope, yeah, this is, in my opinion, the decision of the government and the politically elected members of a parliament, and their constitutional court does not assess in these questions. This is very important. And this leads me to the next. Therefore, it is so important that all these human rights in these different catalogues, in the domestic constitutional catalogues in Austria, in the Charter of Fundamental Rights of the European Union, and also in the Charter of Fundamental Rights, are interpreted consistently. Yeah? This is very important. And this is, for the Constitutional Court, the crucial point. And this is the thinking behind the judgment concerning fundamental rights, concerning the Charter of Fundamental Rights of European Union. The consistent interpretation as a control instrument. For asylum, it's very interesting because the judgment concerning the Charter of Fundamental Rights of the European Union, there were asylum cases, yeah, and two asylum cases, I think one of China and the other of Armenia, and there you can see that if you come back to politics, yeah, in my opinion, concerning neutrality, the position of Austria, besides the Constitutional Court and the political position, is always in affairs like Syria or something like that, or in wars, to grant asylum, yeah, to be very generously in granting asylum. And this is also a kind of active policy of neutrality. And this active policy of neutrality is always rooted in these two principles, the democratic principle and the rule of in these two constitutional principles, the democratic principle and the rule of law. And so it's always a question of check and balances. And so the job of a judge, of a constitutional judge, is in the end not so far away from really political questions. You must only find a really procedure that can control for the public what is the duty of the Constitutional Court and what is the duty of politicians, yeah, and what is the job of the politicians. I think that's the crucial point, and to make that very transparent. Yeah.
this last point you made, Professor. Yes, where's the limit between the Constitutional Court acting as a court with legal instruments, and where the Constitutional Court might even cross this line
Yes.
and become proactive.
Yeah.
This has occurred in Slovenian Constitutional Court's tradition, history, on several occasions. Might in the future again. Of course, it was always such a step criticized, praised by one side, criticized by the other, but that is really one of the crucial points. Also, concerning the foreign policy, is the Constitutional Court, the constitutionality, allowed at a certain moment to step in and get involved also, I would say, not within stricto sensu legal matters. The life many times requests it. One should be full of restraint. One should be cautious. That's my opinion. One should do it with a trembling hand, but when necessary, one should do it. For the sake of protection of human rights, for the sake of protection of justice, legal state, values of a society, embodied in a constitution. But maybe it's the point here where we can make a step ahead and coming maybe to a little bit, yes, a little bit more political sphere. We are, of course, facing at this very moment one, even two, very crucial political crises. There is the, of course, Ukraine, which is very acute, but we will maybe not touch it here, but an ongoing story of Syria. What should be the constitutional principles as guidance? Which constitutional principles should guide European states and European foreign policy in case of such situations? Let us now forget this actual situation, Syria, but have in mind a critical situation. Respect for human rights, protection of human rights. On the other side, non-interference principle, principle of sovereignty of states, so on, which of course both then lead to different actions, to different foreign policy. Hypothetically, one could of course say that following the protection of human rights, one could even end with the responsibility to protect and consequently even with the international intervention. Following the principle of non-interference, one could, of course, end with doing nothing and simply accepting the fact, like in case of Syria, like previously Srebrenica, like previously Rwanda, and many other cases, where, of course, the foreign policy of states, which all, at least European states, we have them in mind, have so far-reaching principle established in their constitution, protection of human rights, in many cases did not react according to this principle. Maybe, Mr. Dedia, would you say something on that, if I was clear enough in my trying to establish this dilemma, which is a typical dilemma connecting constitutionality with the foreign policy of the state. Because at a certain point, one could claim the foreign policy as pursued is actually against the Constitution.
Thank you, Mr. Petric. This problem is for the Ministry of Foreign Affairs, but I try to speak very shortly. I am not a representative of the government for this case. It's alone my opinion.
I didn't say at the beginning, none of us is speaking in capacity of any institution. I am not speaking neither for the Consular Court, you are also not. You're also not speaking for University of Ljubljana, either a professor.
Thank you.
Each one is speaking in his personal capacity.
The burden is off my shoulders.
I try to speak about the Syrian crisis and about the humanitarian crisis in Syria is very serious. All of us know that every day are killing the people, killing the children, women. Have very problem with the protection of human rights, for the life, property, freedom of movements, etc., etc. And after my opinion, the Security Council of United Nations must be decided to intervention in Syria to stop the war, maybe the civil war. How? I don't know, but in practice are some examples for this problem. For example, in Rwanda, Congo, Somalia, etc., etc. The war in Syria is very problem because he's killed the future. He's killed the dreams of the young people. And after my opinion, it's necessary to stop this war. I think that the international communitarian have not been alone, have not intervention alone, but under the the United Nations. I don't speak more, but I said that it is necessary to stop the war. Thank you.
Thank you. Feel like to say something on this, I would say,
Interesting topic, yes.
very controversial topic, yes.
Yes. Well, I'll start with a parallel. I'm not an expert in international law, so I won't be talking about international law. But there was a development in history not so far ago, which actually had an impact that was based on constitutional order of one of the European Union's member states, linked to a question whether there was an obligation to protect victims of military attack in another country. And I'm talking about the question of Srebrenica and the Netherlands forces, which you probably know. When the Netherlands forces, under the auspices of the United Nations, gave up arms and, of course, were unable to prevent the massacre, the Netherlands responded in political sense admirably. The government resigns, they took the political burden on themselves, and it is something that Slovenia can look up to, because in our country the tradition of resigning in any case is not so strong, to put it mildly. But there was a development in the National Court of Netherlands following, where the Netherlands as a state was responsible for damages to those victims. And this was done under national constitutional law. And of course, all these issues of national state sovereignty, protection of human rights, obligations of national bodies to protect human rights in these cases were raised. I won't go into details, and I think that the outcome of this trial, of course, is interesting but not important, but the link is interesting. Whether a failure to do something by a certain state, or maybe by the European Union itself, in another state, which leads to the violation of human rights, can become a point of law and damages to individual citizens. Now, we could go to the example of Syria, maybe the Ukraine. Is it really safe to say that this is only a question of politics, as some of the comments of the diplomats of unnamed country would say about the European Union, with some adjectives or verbs that I will not repeat? Or is it a question of law, or can become at some point, failure to act? Of course, now I'm moving to the question of international, which I promised I wouldn't do, and so I'll stop at this point. But maybe a court will address one of these issues again in another country of the European Union in similar instance, and the practice will develop, and we'll see what happens in this regard. Maybe after accession of the EU to the European Court of Human Rights, such a case would arise, because, of course, the European Union is acting as a whole. So we'll see and hope. Thank you.
Thank you, Professor Kershman. You exactly reacted to my, shall I say, provocation in a way which I am very glad to, because it's really one of the crucial questions. At which point the foreign policy remains, or better to say, is no more only policy but has also legal dimensions. That's the crucial point. Foreign policy, sovereignty, freedom of action, and so on. But where are these limits when the foreign policy becomes bound, not only by international law, diplomatic protection, etc., but also by the constitutional principles, by the constitutional law? And that is exactly the question which I would say is, in a way, irritating to me, to which it's very difficult to give an answer. It's very difficult to give an answer to it, in particular if you are a lawyer and you are working in the foreign service for 20 years as I did. Many times I was, in a way, facing this dilemma. But maybe, Professor Judge, you would also like to react to this.
It's an interesting question, but I want to see it from a practical point of view. In our asylum cases in Austria, we have many asylum cases, many asylum seekers in Austria who are seeking for asylum in Austria. And it's common sense of the Constitutional Court of Austria and even of the Supreme Court of Administration in Austria that asylum law is not to export constitutional standards into such countries from where asylum seekers are coming. So it's not a vehicle for exporting human rights there. It's not a political vehicle, but it's something like only that the reasons of the Convention of Geneva are important in these cases, yeah, and they have to be measured, yeah, and it is not to rule about the status of a foreign country by a court. This is forbidden in our meaning of asylum law. It's only the solving of an individual case, yeah, and then it's finished. The other things are political questions, and this political acting of the Austrian government is restricted by the principles of human rights, and this is the only way of measuring by a court in asylum cases. Yeah.
Thank you. Well, I am looking at my watch. We have maybe time for just one more topic. And this is the topic which we have touched upon earlier. We are in a very interesting situation now. We have the European Court of Human Rights in Strasbourg. We have national constitutional courts and national supreme courts. And we have, of course, members of the EU, also the court in Strasbourg with its charter and its membership in the European Court of Human Rights. When this situation occurred, I remember I don't know whether you have been joining me in Strasbourg at the conference of at the session of the Constitutional Court, of the Human Rights Court in Strasbourg, where the gentlemen there were very optimistic and said that will cause no problems. I must say that I was in a way future seer, because I declared at that time in a statement which I made that I foresee there are tremendous difficulties of legal and also of practical character. And it seems, usually I am wrong, but in this case it seems I was right. Could you maybe have a comment on this situation now?
Well, I've touched the subject a few times because I find it's one of the most important developments that could affect many areas of EU action. Also maybe also unpredictable ones. And I would also say that many people say, also based on the documents, the draft accession documents and so on, that there will be no problems as to the foreign politics and policy of the European Union, since it won't be touched by any of those mechanisms. But I'm not so sure. Why? First, the complexity of the issue, as was mentioned also by Mr. Petric, is something that makes us lawyers not worry. We lawyers don't worry. We make money if the things get complex. So.
Not constitutional judges.
Or professors of law, but maybe professors of law worry. Lawyers in service make money. But the thing is that it's so complex, it's something so complex to combine all these documents that even national legal orders don't know really how to cope with that. And the decision of the Constitutional Court of Austria was a very bold one. We had it translated in Constitutional Court and the university, and we're reading it, and of course find it as an interesting solution to the problems of combining all these issues. Vice President of the Constitutional Court of Germany, Mr. Kirchhoff, just sent me an article he wrote about the combining of these issues from the German perspective. And everybody's dealing with that, and we think it's a legal problem that will limit itself in the framework of constitutional and other court actions in member states. But as I said, the question is also of great complexity because of institutions involved. The maybe well-balanced distribution of powers between the EU institutions, Parliament being political, Commission somewhere in between, the courts being an instrument of law, will be joined by a rather, I wouldn't say unpredictable, but out of this sphere of balance actor, which is the European Court of Human Rights in Strasbourg. It won't be composed by members of the European Union alone. Panels will be deciding about issues relating to EU law, which will be composed of non-member judges, and possibly entirely. Why not? It can happen. And of course, afterwards, when the judgments are issued, the European Court of Human Rights is known not to have too much regard as to whether the judgment or its implementation will cause problems for the member state of the Council of Europe or not to implement it. Let's just remember the question of voting rights in the UK for prisoners. It's giving tremendous headaches to all the prime ministers and parliaments since the judgment was issued. But that doesn't, of course, make anybody in Strasbourg worry. And if such a judgment will address European Union institutions, the worry will spread there. But with all the complexity of decision-making and policy-making in these bodies, the European Court of Human Rights in Strasbourg won't be concerned. So how will the implementation take part? Will the non-implementation, and nobody is really writing about that because it's something that won't happen, of course, we all know that the non-implementation of a judgment by the European Court of Human Rights in Strasbourg by the European Union bodies will cause. What will be the consequences of this? I haven't seen an article written in this regard because it's something we don't say, that European Union will not respect the judgment of the European Court of Human Rights. But what if it won't be able to respect it because of the balances of power within the European Union? Let's say common foreign policy, an agreement European Union made with, etc., is, let's not mention data of passengers, etc., is violating European Convention of Human Rights. Change it. Make another different agreement or something like that. I'm just taking things off the top of my head.
Not with China, but with somebody else.
Do we have an agreement like that with China?
No.
Not yet. So it's something that will cause problems not because of the principle to respect the judgments of the court in Strasbourg, but because of the capacity to do so. Maybe the European Union bodies won't be able to, but what will the message be? The European Union is not respecting the decisions of Strasbourg. What it would be the impact on foreign policy and the position of European Union as such in international bodies. Like, coming somewhere and everybody just falls silent. They are the ones not respecting the judgment. It's not just the UK or Slovenia, but it's the European Union as well. So I think that the consequences of this are really unforeseeable. I've taken a lot of the time because I'm getting warmed up with this topic, and as a professor now, I can speak without a glass of water for 2 hours at least. So now water was given to me so I could last a bit longer. So I'll stop at this point, but of course I'll be ready to discuss it further on if the possibility will be given. Thank you.
Since Albania is not a member of the EU yet and of the Court in Luxembourg, I will not trouble you with this question. If you want in particular to say something, please, but I'm not forcing you to do that.
We are not membership of the European Court of Justice. We hope for the future. We're
It is
waiting.
bright.
Yes. Thanks.
At least for somebody.
Okay, thanks.
Thank you. You
Yeah.
say something to that.
I think there are, from the Austrian domestic point of view, there are some additional problems because the Austrian Supreme Court of Administration and the Oberste Gerichtshof, the Supreme Court in penal and civil matters, were always orientating to the European Court of Justice and seeking for a preliminary ruling. And now we have the Constitutional Court as another player in this complex situation. So it's not a situation only between Strasbourg, Luxembourg, and Vienna Constitutional Court, but it changes also the relationship between the Supreme Courts in their understanding. So I think the situation has become really difficult under various aspects, the domestic aspect and the aspect between the three different courts, Strasbourg, Vienna, Austrian Constitutional Court, and Luxembourg. So, and we will see what the future brings.
Exactly the same problem we face in Slovenia, because according to our now arrangements, a preliminary question to Luxembourg can be made by both Constitutional Court and Supreme Court. Internally, the Constitutional Court can annul, can change, can declare invalid any decision of the Supreme Court, which is against the human rights and so on. But now, the Supreme Court will ask for the preliminary opinion in Luxembourg. It will get the answer.
Yeah.
How can then Constitutional Court
Of course, that's the problem.
go against such a decision of the Supreme Court based on the preliminary question of the Luxembourg? It is just
that's
the
crucial
detail
point.
which proves also in our case this I would say unclear situations
Yes, of course.
which have occurred with this on the first side prima facie so inviting decision, let us join the Strasbourg Court and let us somehow be a member of the Council of Europe, EU as such and so on, without enough thinking of its practical implications. I think we have more than exhausted our time. Is there any question or any comment by the audience? Please. Here and
well, it is working. Oh, finally, we have the microphone. Dear Professor Petric, President Emeritus of the Constitutional Court of Slovenia, dear President Delja, dear Professor Kershevan, dear Judge Bakler, thank you very much, first of all, for coming, for responding positively to our invitation. And I think, Professor Petric, that's true. You are wrong sometimes. It was really interesting topic. It is a really topic that, as you can see, the conference is still not officially open, but the hall is almost full of persons. So I'm very proud of that. And given that we are running out of time and I would like to be short, I was, in my first life, I was a sort of lower student. Then I switched to the foreign policy. And then I would like to ask you something that is very much interested for us that are involved in the foreign international relations. You are always the eminence grise of the foreign policy. You are there, but nobody knows that you are there. And you are the last wall of our institutional system everywhere in every nation. Now I would like to ask you directly, given that you're not speaking on behalf of your institutions, but as yourself, if any time in the history, not only in your history, but in the history of your constitutional courts, you ever received any pressure to decide in one way or in another way from the politics, from the ministers, and how it happened, if the positive is the answer, and if negative is the answer, well, I will be very much surprised.
Dr. Geiser, I will answer this and then I will give you the floor. Or maybe I give you the floor first and then we answer together. Please go ahead. Yeah, you have the floor.
As you wish. Is this working? Okay. Steven Blokmans, my name. I work as an analyst at the Center for European Policy Studies, think tank in Brussels. And I'm a lawyer by formation as well, so I kind of muddy the pool. And can I maybe tease the panelists a little bit on the title of this session, which was EU foreign policy. The way I understand it, as a foreign policy analyst, would be in the expansive sense. Foreign security issues, you mentioned Ukraine, you mentioned Syria, not necessarily issues of the external dimension of the internal market in relations with Switzerland, not necessarily asylum cases. Although it is good to hear, of course, that from a member state perspective, in constitutional court perspective, there is this safety valve to what one could perhaps, and here comes one of the teasers, to what could be perhaps dubbed as EU constitutional law. And the EU constitutional law would consist of, well, the legal principles and objectives on which the European Union is founded, laid down in the Treaty on the European Union, its constitutional document, and which of course have all the aspects which you mentioned, human rights promotion and respect for international law writ large, but not the judicial function. The European Court of Justice is left out of, does not have any jurisdiction over the sphere of classic foreign policy, EU foreign policy. So it's good to hear that there is this safety valve at a national constitutional level. However, my question is this. EU foreign policy is often criticized as non-existent. It is very hard for the 28 member states to cobble together, on the basis of the procedures which are laid out in the Treaty on the European Union, which require unanimity, a common stance, a common position, a common action. Ukraine, it took quite a long time before the European Union got its act together. Syria, the member states are hopelessly split on the question of providing arms to opposition groups. There is no common stance. So here's my question. Is there perhaps too much constitutional law that hampers the European Union in effectively rolling out its foreign policy.
Okay, first to your question, which is a rather simple one, Dr. Geiser. Let me put it that way. I was in my position as a constitutional court judge, in my position as a foreign diplomat, as a diplomat of Slovenia. Of course, I was given instructions all the time. In 98% I followed them. Sometimes I dared to act on my own. And in few cases I even refused and said straight to the then foreign minister. But that was a kind of unique position which I enjoyed in our diplomatic corps at that time. It was a little bit risky, but was a kind of privilege. But it was many times said, and that was somehow a message to me, we should not appoint him there or there on this or that position, because with him you are never sure what he will do. And that is a kind of, shall I say, not pressure, but as a kind of, understanding that this is somebody who might not follow something which he doesn't believe himself. But anyhow, but to your question, which is more in a way, it's very exciting. I agree with what you have said, basically, in introduction to the question. But the question whether we do not have maybe too much constitutionality and constitutional limitations, which in a way prevent European common foreign policy to be established and acting. Well, you may change the terms. You may say that maybe there is too much understanding of sovereignty of states, which is still in a way slowing down, let me put it that way, European integration, and by it also European common foreign and security policy. Are there some constitutional limitations? Maybe yes, because according to our constitutions, we have to protect our sovereignty as established in our constitutions. But I believe that the constitutionality is not really an obstacle to the establishing and full action of European common foreign and security policy. I rather believe that, again, it is a quite a general term, there is lack of political will. But when I say political will, of course, I mean all these things which are there. The future elections in a country, the public opinion, all kinds of things which, of course, have an impact on slowing down the process of coming to a joint position. And here I believe that if we push into the foreground some constitutional principles, like, for instance, human rights, protection of human rights, and that was actually my hidden point here, we in a way push for a foreign policy which would be based on a certain principle or certain principles and would be binding for European governments to pursue because of the constitutional principles which are binding them. Shall we have one day maybe even a European Constitutional Court? I don't know. But who knows? We will have some centralized banking institutions. We will have some other European institutions. Maybe one day we will have maybe even some court somewhere which will be looking at the European Union actions domestically, inside and outside, from the point of view of some constitutional principles. But that is very far future. But you wanted to react to that. also. But the question is very exciting, which you raised.
Yeah. As to the question of too much constitutional law, which is a very interesting question, I would maybe start with the fact that we have a lot of, as explained several occasions here today, a lot of documents relating to human rights that can be named European Union constitutional law. It's the Charter, it will be the European Convention of Human Rights, common traditions and practices of the courts, etc., etc. But despite all these documents, there remains exactly the position and the written, of course, rules of all member states of the European Union that the common foreign and security policy is exempt from jurisdiction of European Court of Justice. There's a special chapter, special procedure, it's excluded from the internal market rules, etc., etc. So, on one hand, we have a lot of rules, and on the other, we have an explicit statement that no mechanism can be used in the sphere of foreign politics or policy of the European Union to enforce it. So, what we were talking about today, as I find with one of the common denominators, let's say, was about different developments as an unexpected way, maybe, where these documents, these principles, these rules could affect foreign policy of the European Union. And, of course, it won't be institutionalized as such. I doubt it seriously that the member states would give up the part of their sovereignty in transfer of this powers to the European Union to a larger extent that they already have, subjecting it to a judicial body at some point. And many say that it's incompatible. But many cases have arisen that show that it is not maybe so incompatible in substance, and that there are ways slowly going through different institutions that encroach in this sphere which were not expected before. I don't know whether this is something that is a general tendency that will develop further, but I expect it to, because if you give enough rules to enough people and, of course, skilled lawyers, slowly and surely the practices will develop, as European Convention on Human Rights shows. It's seen by the court as a living document and it's being developed further. And even if there were no problems with the Charter, I say that probably the ECJ in Luxembourg will sooner or later say it's a living document, and the Commission has to respect this in different areas that affect foreign policy as well. I don't know that. I suspect that it will happen. And as to the development of common principles, national principles, constitutional principles within the European Union, I remember an interesting story which was affecting foreign politics of a country. I'll be very brief. The president of the Constitutional Court of Germany, Mr. Voskuhle, was visiting the Constitutional Court this year, held a speech, and he explained an interesting case they had about the parliament in Germany, Bundestag, seeking documents from the German government relating to negotiations within the European Union framework because of their desire to make this process transparent and the government responsible. The government said no. There are no rules as to that, neither in the European Union law and, of course, not in our constitutional order. There is no obligation of legality as such, and it would hinder our actions within the diplomatic efforts that Germany is trying to pursue. So the case came to court. They decided on it. I haven't read the decision, so I'm quoting Mr. Voskuhle. And one of the parallel developments, a bit unexpected one, was that the parliamentarians got their materials before the court decided from their Austrian colleagues. Because obviously the practice in Austria was different. You have more transparent process of European Union negotiations, and your members of parliament were able to get those documents, and they were kind enough to send them to the parliamentarians in Germany. So is there a common principle developing? I would say yes. it would be ridiculous for a court in Germany or Slovenia or somewhere else to say, no, you can't have these documents from our government in the future, just go to the Austrians. So I think that we'll have unexpected developments in the sphere of law affecting politics within the European Union and outwards in the future. So I will stop with that. I hope I answered your question. Thank you.
So I think we are coming to the closure of our session because everything has to be ready for the official opening. Thank you very much for the audience. Thank you very much for the pan-European movement. I think you are on a good track. I think all those four sitting in the panel here, we believe in Europe. We understand that Europe has to integrate itself, not to play a role by power around the world and so on. No, this is history, this is past. But to secure our values, to secure our well-being of our people, our way of life, our security, that is an important task which we are to do. And also the lawyers are involved in that. As I said at the beginning, the lawyers' work seems sometimes to be dull, but when you go profoundly into it, you can see that sometimes it's also exciting. I hope that this our session was not too dull. Thank you very much.